Hello everybody and welcome to the intellectual property training for module 1. We will discuss several topics concerning the intellectual property, what is intellectual property, and how it relates to micro, small, medium enterprises. So, why people innovate? Innovation is a very complex process, and the intellectual property works to bring together individual acts and social movements, and innovation requires both individual creativity and broader social adoption and societies that support both to do the best. So how innovation definitely has an impact on society. Innovation can do very big things. It can explore numerous ways the nature laws of our world and also can solve social problems. Nevertheless, there is also a perspective in the society. We have the legal perspective and the business perspective. For the legal perspective, if we take into account the US Constitution, in order to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. So that's from the law. From a business perspective, the business people consider the intellectual property to be a management tool for converting human capital into value by defining and capturing new knowledge, and that intellectual property is the legal protection form for the intellectual property assets, which belong to a company, research institution, or an individual. In order to do that, there were set some treaties to set some standards that are incorporated in the national legislation, and they're protecting the intellectual property rights. In this slide, you will find several treaties that they were established. From 1883, 11 nations established the Paris Convention, which is the first big set mark for the intellectual property protection. Then another important treaty is the Berne Convention for copyrights, dating 1886. We have the Madrid Protocol that was adopted in 1989. And then we have the World Intellectual Property Organization, which administers the treaties. And there is a Patent Cooperation Treaty that a lot of countries, 193 members, are following all the rules and regulations. The Patent Cooperation Treaty was concluded in 1970, and since then 132 nations have joined, which of 50 of them in the last decade. Which are the social forces that drive innovation? Intellectual property is one of the several social forces that drive innovation. Other drives are including such as market forces, where you have the investors with their interest, the market demand, the entrepreneurial management skill, and the labor pool. Also, we have geographical factors such as location, the natural resources, laws regarding taxes, the environment, and the product liability, government interventions such as educational standards, procurement practices, subsidies, and altering trade barriers, governmental and philanthropic funding for research, cultural activities, prizes, awards, and others. So as we see, there are a lot of forces that they drive innovation in our society. So there are 8 arguments justifying the intellectual property rights, and there are several theories about that. We have the incentive, the reward, the labor, the morality, the public disclosure, the technology transfer, the technology development, and the industrial policy. All these arguments interrelate and overlap. Regardless the arguments justifying the intellectual property rights, there are also criticisms for the intellectual property. Many say that it keeps knowledge of the public domain, that increases costs, creates monopolies, companies invest in profitable markets, and pushes people from cooperation into competition. The system is expensive to maintain, and the intellectual property requires elaboration in the national legal and regulatory institutions, and finally threatens the collective online open access culture. But it's very important to realize that intellectual property plays a very significant role in the growth and success of the micro, small and medium enterprises in various ways. Intellectual property rights offer protection for innovation, branding and marketing, help the market expansion and the licensing opportunities, having attractive financing and investments, increase the competitive advantage and the market positioning in the specific domain that the enterprise has a product or a service, and enhances the collaboration and the partnerships. So now we will discuss the several different types of intellectual property. So we have patents, which are related for new inventions. We have utility models. We have the copyright. We have trademarks. We have registered designs, trade secrets, and their geographical indications. Each type serves for a specific purpose, a product or a service, its appearance, if it's something that we need to protect in a specific way as a part of a music, or a design, or a geographical indication, an origin, or anything that is specifically to the product, the service, or the process. Apart from the different types of intellectual property, there are different protection strategies for our intellectual property. We have the registration of our intellectual property, confidentiality and trade secrets for our product and services, licensing and agreements, either for the intellectual property that we can license, or we can have an agreement with another company or a customer. We have enforcement and litigation for our intellectual property, international protection, brand protection and monitoring, technology and digital protection, and collaboration and partnerships. These are some of the protection strategies that we can have for our intellectual property. Now we will discuss about the specificities depending on the area of the protection. So concerning patents, protect the inventions, providing exclusive right to the inventor for a limited period. Cover new and non-obvious inventions in various fields such as technology, pharmaceuticals, and engineering. The patent application process involves disclosing the invention to the public in exchange for exclusive rights, and grant the inventor the right to prevent others from making, using, selling, or importing the patented invention without the permission of the creator. For trademarks, they protect brand names, logos, slogans, or other distinctive signs that distinguish goods or services. Can be registered to obtain additional legal protection, but unregistered marks may also have some level of protection. It helps consumers to identify and associate products and services with a particular brand, and it can be renewed indefinitely as long as they are actively used and maintained. Concerning the copyright, they protect original creative works such as literary work, music, art, film, software, and architectural designs. Copyright protection arises automatically upon creation of the work and grants the creator exclusive rights. It gives the creator the right to reproduce, distribute, display, perform, or modify the work. Have a duration that typically extends for the life of the creator plus a certain number of years after their death. Concerning the industrial designs, they protect the aesthetically or visual aspects of a product or object. They cover the shape, the pattern, the orientation that gives a product a unique appearance. Protection can be obtained through registration, which provides exclusive rights for a specific period, are often used for consumer products, furniture, fashion accessories, and packing. Trade secrets. Trade secrets are protecting confidential business information that provides a competitive advantage. Unlike patents or copyrights, trade secrets are not publicly disclosed and rely on maintaining secrecy. Can include formulas, recipes, manufacturing processes, customer lists, or marketing strategies. The protection of trade secrets requires implementing measures to maintain confidentiality and restrict access to authorized individuals. And finally, we will list the difference between knowledge and open data versus protected data. There are several levels of secrecy that we can keep, or openness. We have the public domain, everyone has access. We have broadly accessible with minimal limitations. We have broadly accessible subject to agreed limitations, accessible for limited purposes, and not accessible at all anywhere due to highly restrictive IP rights. So there are several levels of the protection that we can have for our data, our new knowledge, and so on. So that was the end of the module 1 for the intellectual property training. Thank you very much.